My name is Tebat Kadhem, and my co-counsel is Shir Zisckind. We are here representing the Appellant K.J.M. and the case Kasper. Would your honorable justices like a summary of the facts?
No, thank you.
Thank you. We, the appellants, will be making 3 submissions today. We submit that the youth criminal justice system is a separate and distinct system, and the Jordan presumptive sealings and framework should introduce separate and presumptive sealings for youth. We submit the delay timeline during trial justified a stay of proceedings, as the calculations of the delay set forth by the Supreme Court of Canada was inappropriate. And finally, we submit that the delay timeline during trial did justify a stay of proceedings, as it did meet the requirements, and therefore K.J.M. Section 11B charter right to a timely trial was violated. I will be submitting our first submission, and my learned co-counsel will be making the second and last submission. Would it please the court to proceed?
Yes, please.
This case primarily is about the extent to which young people with their distinct separate criminal justice system is protected under Section 11B of the Canadian Charter of Rights and Freedoms. The youth criminal justice system is distinctly different than the adult criminal justice system, and because youth are treated differently in court proceedings, sentencing, and all aspects of the criminal justice system, in fact, youth courts are the only separate system of courts in Canada, differing from the adult criminal justice system. Provincial and superior courts might have different types of courts, like drug and mental health, and special or even statutorily created courts within the justice system. But that is not the same as having a parliamentarily codified and distinctly separate criminal justice system. We see this distinct separation in the corrections system, where young persons are cared for separately than adults, and this translates to separate correctional institutions. Young persons have different sentencing maximums. Even youths who are convicted as adults receive lower sentences and lower parole eligibility requirements. And applying a one-size-fits-all presumptive sealing approach to what is an unreasonable delay at the adult criminal justice system is more than unreasonable and inappropriate in the youth criminal justice system. It is not enough to treat youthfulness as a mere factor to be considered under the current Jordan framework. We submit that young persons need a distinct new standard presumptive sealing under the Jordan framework that recognizes their heightened vulnerability and their development and unique perceptions of time. We are asking that young persons are treated differently, but not to the extent that they receive charter rights that adults do not receive, but they receive different applications of the justice system because of the distinct and separate nature of the youth criminal justice system. One may ask, is there indeed a problem in delays, trials respective to youth? And yes, there is a problem with delay in the system in its entirety. In fact, the court recognized that in establishing the Jordan framework. But in the pre-Jordan era, what we considered unreasonable delay for youths was less than what was unreasonable for adults. We saw youth cases being stayed for delays.
Counselor, I'd like to ask you a question. In terms of when you say that there is delay in the overall system, we acknowledge that these delays, as stated by the Supreme Court, do not happen as often in the youth criminal justice system as they do apparently in the adult criminal justice system. This is why the below ceiling test has been considered to be flexible enough to accommodate the youth criminal justice system. So what kind of evidence or basis do you have submitting that the youth system is suffering from the same types of backlogs or too many cases not being dealt with quickly enough? How do you submit that you have evidence for that?
Well, it isn't about the certain level of delay that is being seen within the youth criminal justice system. It's also about the standard that we put up for presumptive sealings for youth. According to the Youth Criminal Justice Act, youths do have a claim to timely and highly timed trials. And when we do not uphold these principles, we see that we see a diminished due process within the entirety of the youth criminal justice system.
Sorry, but counsel, nobody is saying that a trial judge can't take that into consideration. And we have youth that run the gamut, 12 to 17 years old, that are very different. So all we're doing is saying the ceiling is 18 months. A trial judge can consider the individual circumstances of a youth. Why do we need to lower the ceiling, given that we should let our courts do that?
Of course. The previous justice had referred to, more explicit evidentiary-based reasonings as to why we need a lower presumptive ceiling. But what we must consider is that prejudice within the youth system is more of the time implicit, and we must respect that prejudice and youths being able to advocate for themselves when it comes to the prejudice that they are experiencing. We must advocate for them so that we are preventing this prejudice from happening instead of rectifying.
I agree with you, but wouldn't you agree with me that it's the trial judge that's in the best position to do that?
What we see a lot of the times is when you have like a ceiling at 18 months and it is recommended for youths to not reach that ceiling, some of the justices will, for example, in this case, even though all of the facts clearly show that a stay of proceedings should occur, they say no, because it's still, the ceiling has not been touched. And to prevent hard cases from going to 18 months, which in a youth case is unreasonable, we must lower that hard line so that judges, even if they do err in their reasoning, it does not protect. It protects the youth. So we must be proactive in setting that ceiling instead of allowing the system, which has in the past produced more prejudice because of the heightened bureaucracy of the courts. We must not put the system in the hands of the bureaucracy and maybe judges who
so is it your argument
making the right decision.
Is it your argument that we want the system to conform to this 15-month ceiling, and as a result, we'll take cases? Okay, I can buy that.
The system is flawed, and judges can be flawed. Thus, we must put into law insurances for youth.
Okay,
I don't think I have flaws, but that's okay, counsel.
Counsel, I have a question. Would you not agree that there exists no evidence to support your basis that there is a delay problem in the youth court?
You have 3 minutes, counsel.
Quick question. Can you just repeat your question? Your question again?
Yes, indeed. Would you agree, counsel, that there is no evidence that supports your position that there is a delay problem in the youth court system?
Even if there is no evidence, we as a court, and what we are asking is that we look to protect the prejudice that could be made through this presumptive ceiling. In Ontario specifically, we see a lot of resources being strained, and if we cannot rely on the current system to uphold, or right now there might not be evidence.
Sorry, counsel, is it your submission then that you're asking us to find that there was an 11B violation based on what you've said is little to no evidence of actual delay within the system?
The evidence that we are seeing right now is from the Mooring framework, just because it takes time to build up evidence. We shouldn't rely on the previous statistics seen in the Mooring framework to to justify not allowing a presumptive ceiling to be lowered now.
Sorry, counsel, I'm going to interrupt you one more time. Is there statistics in the Morin framework that indicate that there is delay in the youth criminal justice system?
Yes, that is why, you know, in its entirety, the criminal justice system, specifically, you know, in very rural and very, like, in a lot of different areas within Canada, we do see a heightened delay. And to help prevent that from happening in the future, we must be proactive.
And is that the case in the youth criminal justice system specifically?
We did see in the Morin framework, you know, prejudices that have been raised. But what we are trying to prevent is, you know, the implicit prejudice that can take place, even though there isn't any evidence right now, or a lot of cases right now. What we must do is try to protect the Youth Criminal Justice Act and the precedent and the acts that support youth in the criminal justice system. May I have an extension of 1 minute to conclude?
Yes, that'll be fine.
Youths are punished differently in the system. What would be appropriate for an adult as a sentence would be unconstitutional for youth. In fact, we see this in RVDB, where an adult sentence given to youth is struck down as unconstitutional, as with the presumptive ceilings. We're seen as not recognizing the principle of fundamental justice, that young persons are afforded a diminished moral culpability. You know, no approach is perfect, but we recognize that Parliament has codified the Youth Criminal Justice Act, that there is a special duty for youth to get court proceedings and matters finished with quickly. It is a problem to have a framework that gives young persons their Section 11B rights and not uphold the very principles that are set out to protect them in the Youth Criminal Justice Act. To conclude, the system of presumptive ceilings might be imperfect, but the onus for young persons to show unreasonable delay should be lowered, because having youth continuously proving their prejudice every time. Instead, we submit this court to lower the Jordan presumptive ceilings for young persons and allow this appeal. Thank you, Honorable Justices, and I give the floor to my honored co-counsel, Shir, to submit the rest of the submissions on behalf of the appellant, K.J.M.
Thank you, counsel.
Good morning, Honorable Chief Justice and Justices of the Supreme Court of Lions Cup. My name is Zisckind, initial S, and I will be making the final two submissions for the appellant K.J.M. Would it please the court for me to proceed?
Yes, please.
The appellant's third submission is that the calculation of delays set forth by the Supreme Court of Canada were not appropriate, and the appellant's final submission is that if this court chooses to apply the below the ceiling test has been satisfied, and therefore the appellant's Section 11B rights have been violated. Firstly, Your Honor, I would like to draw your attention to paragraph 102 of the case at bar. The majority erred in this paragraph when they determined that the vacation taken by the trial judge should be subtracted as a, quote, practical reality. Yes, judges take vacations. They're human beings, but the constitutional rights of minors do not get suspended every time that a judge walks away from their desk. The courts still have a responsibility to ensure that institutional delay is mitigated as much as possible, especially considering how close this was to the 18-month ceiling, the fact that this delay did take place after Regina and Jordan, and that ceiling was closing in, and the heightened prejudice that minors face within the criminal justice system. As the dissent further states, in paragraph 176, the transcription error could have been, quote, reasonably mitigated, and ultimately the error falls on an agent of the state.
Sorry, counsel, what was the date of the issue with this transcript? Do you remember what it was?
It was approximately 2 months before the trial, Your Honor.
It was 2 months before the trial?
Yes, shortly after Jordan was
I have September 6, 2016. Is that after? You sure that's after Jordan?
Your Honor, just a moment. Do you mind if I have a moment to consult my notes?
Of course.
Thank you. Yes, Your Honor, it was after Jordan.
Okay, thank you. Yeah, July 8th. Yeah.
Okay. Finally, while the majority of the case at bar did
Counsel,
Sorry,
I'm
Your
sorry.
Honor?
Counsel, I have a question.
Of course.
Can you please perhaps tell this court how the transcript issue could have been mitigated?
Your Honor, if the transcript was reviewed before the judge left for vacation, she could have ensured that it was accurate and it was ready for trial, first and foremost. Moving on, Your Honor, while the majority of the case at bar did take place under Moran, the delay is not justified under the transitional exception. The majority states in paragraph 112 that the high tolerance for institutional delay that existed under Regina and Moran should also be considered when applying the transitional exception. However, Your Honors, a culture of constitutional violations does not justify more constitutional violations. My client's constitutional right cannot be suspended because other constitutional rights of accused persons were also suspended at that time. Even if we go so far as to accept the majority's arguments, as Justices Abella and Brown point out in paragraph 200, the delay still would not have been deemed acceptable under the Moran guidelines, given the overwhelming prejudice that the accused faced relative to the inexcusable institutional delay that repeatedly emerged throughout the trial.
Yes, but counsel, under Moran, the accused also needs to show that they care and they're taking it seriously. Your client had a very lackadaisical attitude towards arriving to his trial. Does that not show that he really doesn't care about how this case proceeds?
Well, Your Honor, that was one out of 13 court dates that my client was meant to attend. But prior to that, we entered an early plea. We repeatedly noted that our client's section, the defense counsel, repeatedly noted that the defendant's Section 11B rights would not be waived and that there was a consistent issue of delay that they had noted throughout the course of the trial. Your Honor, the defense counsel was taking activity at that time to point out that the Section 11B was an issue here.
Well, he just said on the record it's not getting waived, and that's what counsel always used to do under Moran. They would just quickly pad the record and then move on. I think Justice Mulder said that can't happen anymore. Counsel needs to take proactive steps to find earlier dates, to suggest they want it to move forward. How did that happen in this case? I realize most of the time was under Moran.
Well, for instance, Your Honor, they entered an early plea. They noted that repeatedly throughout that delay was becoming a problem. So they didn't just say that the Section 11B rights weren't being waived. They actually called attention to them and said that this was becoming a significant and severe issue throughout the course of the trial.
Where did they do that?
Your Honor, may I have a moment to consult my notes quickly?
Of course. You don't need to ask for that, counsel. Go ahead.
Okay. Your Honors, this dissent does point out in paragraph 196 that from the beginning, K.J.M. entered an early plea and that counsel repeatedly noticed his concerns about the delay. In paragraph 196, again.
Okay, counsel, before you move forward, I just want to indicate that the test is not whether the case should have reasonably have been completed in less time. And we do acknowledge that this is right around that threshold. Can you tell me why that specific word, markedly longer than it reasonably should have? Can you tell me what you attribute to supporting that markedly longer period of time?
Well, of course, Your Honor, I would first draw your attention to paragraph 118, when the majority stated, quote, "It is not unreasonable to expect that a straightforward case like this could have been completed within a year."
Sorry,
18 months.
where is that, counsel?
Paragraph 108, Your Honor.
108.
Yes. So, Your Honor, 18 months, so we're already exceeding 8 months here. It's almost 50% beyond what the majority themselves is acknowledging would have been reasonable for a case of this nature. And let's not forget that under Moran, we could only accept about 8 to 10 months of actual institutional delay, and we're now at 18 months overall. So, Your Honor, especially considering the amount of prejudice that my client faces as a young person and how this delay would have affected him, and considering the fact that the Youth Criminal Justice Act did exist under Regina and Moran, and Section 3(1)B was still prevalent, and the court should have been aware that.
Counsel, is
yes.
there any evidence in the record that actual prejudice was faced? I mean, of course, there's a time delay here that we see, but is there any other evidence in the record? So I know the examples were given when it affects an individual mentally. That was proposed theoretically, but in this case, were there any explicit examples?
Your Honor, I would like to bring your attention to paragraph 51 to paragraph 53 of the case at bar. Or sorry, paragraph 55, 51 to 55, Your Honors, in which the majority themselves outlined 5 different areas in which young people face additional prejudice. And I would note that these prejudices are inherent to the fact that they are a young person. They don't just rely on whether or not the young person was held in custody or what the release conditions were. Things like reinforcing the connection between actions and consequences, preserving the right to make full an answer in defense. These are inherent to the fact that he was a young person. So this is evidence of actual prejudice that my client faced throughout the process.
Counsel, did you do a calculation of delay under Moran? Can you give me a number?
Yes, Your Honor. So we side with the dissent on this. So we reach a 2 3/4 months of institutional delay that was caused by the institution itself. 5 months of Crown delay that was caused by the voir dire. The additional 1.5 months that was caused by the transcription error, which we do not believe or we do not submit, was a discrete exceptional event. All in all, totaling 18.5 months, Your Honor.
Thank you.
1 minute and 10 seconds remaining, counsel.
Counsel, could I ask for an extra minute extension?
Yes, that's fine.
So moving on to our final submission, Your Honors. Should this court find that the 18-month ceiling should apply, the defendant would absolutely meet the requirements for the below-the-ceiling test laid out in Jordan. The qualifications for the below-the-ceiling test, in order to qualify for the below-the-ceiling test, the defense must show that they took 1, meaningful steps that demonstrate a sustained effort to expedite proceedings, and 2, that the case took markedly longer than it reasonably should have. The meaningful steps test, as I've previously discussed, was already satisfied. We entered an early plea. The defense counsel entered an early plea. They engaged in expediting the proceedings as much as possible. And further, my apologies. And further, the majority themselves acknowledge in paragraph 106, the defense is expected to act reasonably, not perfectly, and they should have been offered the benefit of the doubt, especially considering that this was a transition, this was not an explicit requirement under the
Sorry, counsel, to clarify, you're at 10 minutes, you have 2 left. My bad.
Okay. Your Honor, it's important to note that the key factor of the second requirement of the below-the-ceiling test is not whether or not the case took reasonably longer than it should have, but whether it took markedly longer than it should have. I submit that this case did indeed take markedly longer than it should have, as I previously addressed. Not only for the reasons that I have previously addressed, but also because the issue at the center of this trial was not complicated. It was whether or not a self-defense justification could be applied for an assault charge. And again, as the majority themselves stated in paragraph 108, it is not unreasonable to expect that a case like this would have been completed within a year. By the majority's own analysis, Your Honor, this case took over 8 months longer than it reasonably should have taken.
Now, counsel, we have a stabbing, an aggravated assault. So, I mean, the Moran guidelines. I mean, you're over the youth guidelines. You're right in the range for the regular Moran guidelines. Can you address if the seriousness of the case under Moran really shouldn't get you a stay, and whether or not that's even relevant in the below the ceiling test?
Well, first of all, Your Honor, I would point out that the appeal did take place before the actual conclusion of the trial. Therefore, the actual conclusion of the trial itself is still in progress at the moment because the appeal took place beforehand. for.
So I don't really understand that point, but that's okay. You can move on. I don't know how relevant it is.
Well, moving on, Your Honor. The defendant's constitutional right was still violated. The seriousness of the offense of the charge itself, yes, it was serious, but there's still a violation here. There's still a constitutional violation here that the defendant fundamentally faced as well. So, so drawing attention to that.
But counsel, Morin very clearly allows me to consider the societal impact and the interests of society of trying a case. I mean, if this were shoplifting, then sure. But we're talking a stabbing. Does that not raise the Morin guidelines a little bit? And does that not justify being a little bit below the ceiling?
You have 40 seconds, counsel.
I would draw your attention to page 787 of Regina and Moran, in which the majority stated, quote, as the seriousness of the offense increases, so does the societal demand that the accused be brought to trial. So yes, the seriousness of the offense would be considered at the time, but it would have also meant that this was expedited, and the trial judge should have been aware of that.
Very good, counsel. Thank you.
Your Honor, I will proceed now to my conclusion. So in conclusion, Your Honors, the appellant's position is that the Supreme Court of Canada erred in their finding that the presumptive ceilings in the Jordan framework apply to youth criminal justice proceedings.
I'm sorry, counsel, you're at 13 minutes.
Okay. Thank you for your time, Your Honor, and thank you.
Thank you, counsel.
Thank you.
Can I proceed, please?
Yes, please do.
Good morning, Justices and Chief Justices of the Honorable Court of the Lions Cup. My name is Hamera Islam, and along with my co-counsel, Mayuri Kalwani, we represent team number 15 and the respondent, Her Majesty the Queen, in this matter. The respondent requests that the Supreme Court of the Lions Cup Moot uphold the lower court's decision and dismiss the appeal. The respondent will be making two submissions today. I will be addressing the first submission, and my co-counsel will be addressing the second submission. First, the respondent submits that the presumptive ceilings in the Jordan framework do apply to the youth criminal justice proceedings. And the second submission is that the delay in the appellant's case was reasonable. In support of my first submission, the respondent submits that the presumptive ceilings in the Jordan framework apply in youth criminal justice proceedings. And this is supported by the following. First, the Jordan framework can adequately accommodate the increased need of timeliness as mandated by the Youth Criminal Justice Act for cases involving young accused. And second, there shouldn't be a separate ceiling to give effect to an accused young person's Section 11B right. I begin with my first submission that the Jordan framework can adequately accommodate the increased need of timeliness mandated by the Youth Criminal Justice Act, YCJA in short, in cases involving accused a young person. The majority in the appellant's case, as I would direct the court to refer to paragraph 2 in the appellant's case, state that the Jordan framework in 2018 is established to eradicate the culture of complacency towards delay that was very evident in the criminal court system. This culture confused an appropriate determination of Section 11B of the Charter, which states that any person charged with an offense has the right to be tried in a reasonable time. It is important, and it is the respondent's submission, that the determination of Section 11B of the Charter is predictable, simple, and certain because of the underlying notion of procedural fairness. The Jordan framework consistently provides that procedural fairness by way of applying a clear-cut ceiling of 18 months in provincial courts and 30 months in superior courts. And this case of an accused young person, which is the appellant, is no exception to the rule, and it does not compromise the provisions in the Youth Criminal Justice Act. In the YCJA, Sections 3, sub 1, paragraph B, factors in the principles that highlight the enhanced need of timeliness as mandated in the YCJA, namely points 4, which is timely intervention that reinforces the link between the offending behavior and its consequences, and subparagraphs 5, which states that the promptness and speed with which persons responsible for enforcing this act must act given the young person's perception of time. It is the respondent's...
Can you tell me, you've said in your opening submissions that it's your belief that the court system can accommodate the need for timeliness under the YCJ. But you'll admit that we've seen in this specific case, we've seen a situation where the Crown turned around all of a sudden without much warning and required a voir dire for an additional witness, which could be attributed to Crown case management and maybe the need for more Crown case management, especially when it comes to Youth Criminal Justice Act matters. And we also saw a situation where perhaps the judge could have given some explicit instruction to their assistant, to an articling student, one of their clerks, to stop the delay that occurred as a result of a transcript that wasn't complete. So it seems to me that there may be two very clear instances of where the system could have done much better. So how do you propose that that's going to change?
To answer your two-part questions, Your Honor, I will first address the first, which is about the court suddenly changing their position in that a voir dire transcript is important. With respect, we have to honor that the justices in the Supreme Court of Canada are appointed in their positions for the very reason that...
No. I mean, it was the Crown, is my understanding, and is it yours, that the Crown, the requirement for a voir dire in the initial trial was because the Crown required an additional witness, that then a voir dire was required. So it was really the Crown management of the case, was it not?
However, to answer that question, the Crown does have the discretion to do that. Nowhere is it in a statutory legislation or in a in statutory legislation.
Counsel, I think what the Chief Justice is saying is that yes, counsel had that discretion, but it's the culture of complacency that caused them to exercise it in that way. And if the Crown had pointed out the need for this voir dire months before, we might not be here right now.
The culture of complacency, of delay, as it will be attested to in the calculation of the overall delay by my co-counsel, is evident that we have to consider the local culture that the parties reside in. In particular, Fort McMurray has this system that is overburdened as it is, and thus it is the respondent's position that the Section 11B determination has to be so that it gets the gears rolling to finding court cases being resolved in a timely manner.
Sorry, counsel, is it your submission that across Canada, based on what local jurisdiction you're coming from, that people and youth in general have fluctuating charter rights when it comes to 11B, simply based on how busy their court system is?
No. I believe that, it is the respondent's submission that the charter right of Section 11B is uniform. That is so that it addresses that issue of each jurisdiction submitting their need for a quicker trial to be held. That is why we encourage the uniformity of Section 11B as per the majority in the Supreme Court decision. And I would like to support my reasonings with my submissions to follow. Just to address the increased need of timeliness in the YCJA, namely subparagraphs 4 and 5, are already codified in the YCJA, which means that procedures are already put in place to protect the increased need of timeliness as mandated in the YCJA. There is no need to complicate that, and there is no need to complicate the reasonable test in the Section 11B Charter. Second, there is an advantage in the post-Jordan world that the young accused did not have prior, and that is expressed applied prejudice. Mooting was complex in that prejudice was one of the 4 factors that have to be that the youth had to have the onus to bear. And this is an incredibly heavy onus to bear, especially for a youth, because prejudice is very subjective. And to eradicate this, that is why we do not want to infer prejudice, whether inferred or actual prejudice, especially for a youth. Rather, we are setting a clear-cut 18-month ceiling and 30-month ceiling.
So, counsel,
so that
if your argument is we don't want to infer prejudice, didn't Justice Moldaver essentially say that in youth cases we can, because we can take contextual factors into consideration?
Exactly.
So you're saying we can, so is your argument we stick with 18 months and we don't and that's what it is, and we don't consider prejudice on an individual basis? Am I misunderstanding?
You have 3 minutes, counsel.
To answer your question, Justice Moldaver says that Jordan creates ceilings and not floors at paragraph 69 of the decision. This is to say that because Jordan is a transitional case exception, there needs to be some time and some framework to be needed to account for the fact that 80% of the case was held under Moran. However, even under the Moran framework, as the Justice of Court of Appeal Alberta state, the Moran framework would not be fulfilled because prejudice was also inferred by the defense counsel of the young accused. And this is the position that the respondent actually takes, is we would like to direct why defense counsel for the appellant did not do more to expedite proceedings for their appellant. Rather, they are placing this standard of care, or because of their lack of standard of care for their appellant, on the court. However, as much as the appellants were passionate in their submissions, the law has to be with reason, free from passion.
You would acknowledge, though, that 80% of this case was decided prior to Jordan, where there were certainly different asks of the defense counsel in terms of 11B rights. So what kind of level would you attribute to the defense counsel in terms of the fact that only 20% of their case happened after, and the requirements for what defense counsel should do certainly was increased and certainly has changed? Explain that to me in terms of submitting that defense counsel didn't do enough.
You have 1 minute and 10 seconds, counsel.
Thank you. To address that question, I would like to direct the council's attention to, pardon me, to paragraph 10 of the Supreme Court decision, which states that the defense counsel did not meet the standard of care that was owed to their client in attending court late for 2.5 hours, and this attributed to 5 months of delay. The Crown mitigated the youth's, the Crown accounted for the youth's age in not attributing the whole 5 months to the appellant. Rather, we have cut the 5 months into half, so that is 2.5 months that would be attributed to the delay.
Counsel, I assume your partner will be making that point about that 5 months, so I don't think you should use up your time on that point. So.
Okay, thank you. I would like to highlight that the Jordan framework was put into effect. I see my time is running out. Could I have some more time to complete my submission? Justices.
If you'd like 1 more minute, that's fine.
Okay, thank you. I would like to make the last point about why the Jordan framework came about in the first place. Yes, individual interests must be met, but so does societal interests and the interests of the victim in the matter. And this is actually two stakeholders that are mentioned in the ICJA. It is in the public's interest that a case be resolved in a timely manner because of the consideration that it takes a lot of money for trials to actually take longer than it reasonably should have. As for the victim, justice has to be served to them too. And the victim is a young accused. He has suffered permanent facial damage, while the appellant definitely will be charged for 5 months of incarceration. Thank you. My defense counsel my co-counsel will be making the second submission that the delay in the appellant's case was reasonable. Barring all questions, those are my submissions.
Thank you. Just a word to the moderator. On my end, I don't know if it's everybody else's end, but there have been two consecutive people who have presented their case at this point. I'm getting an awful lot of feedback and a lot of delay in what they're saying. I don't know if anyone else is experiencing that.
I am too.
Yes.
When I'm looking at the mute buttons, it seems like everyone is muted who should be. So I don't know if we have any recourse in terms of how to fix that. I'm not IT. I don't have a lot of IT.
I'm going to suggest that everybody mutes, including judges, until they need to speak. I think that will help.
Okay.
Yes. So when I'm observing, it seems that the audio from judges is coming back in. So I'm hearing the second round of speaking coming back from the judge's audio. So we'll just mute everyone, and then when speaking is needed, we can unmute.
Beautiful. Okay, perfect. Thank you.
May I proceed?
Yes, that's fine. Thank you.
Good morning, Chief Justice and Justices of the Honorable Court of Lions Cup. My name is Kalwani, first initial M, and I continue to represent the respondent in this matter. The respondent submits that the total delay of nearly 15 to 16 months in this case is reasonable. To this effect, I have two submissions to make. The first, that the calculation of delay set forth by the Supreme Court is appropriate. And second, that if this court should find that the appropriate ceiling should apply of 18 months, the test for reaching this conclusion has not been satisfied, and hence the appellant's Section 11B right has not been violated. Jordan, at paragraph 96, defines a transitional exception as a circumstance which may arise where the charges were brought prior to the release of this decision. This case is that transitional exception. The most important feature of the Jordan framework is that it sets a ceiling beyond which delay is presumptively unreasonable. Application of this framework, as under the Morin framework, begins with the calculation of the delay, from the charge to the actual end of the trial. In this case, as founded by the majority at the Supreme Court in its reasonings, the net delay is that of 15 to 16 months. We must now assess the underlying reasons that account for the total delay in this case.
Counsel, I'll be very quick. So just from my notes, 15 to 16 months Jordan delay. What's your Morin delay?
Our Morin delay, as Morin sets 5 to 6 months
Yes,
for
just give me,
use cases.
No, I understand that. Just give me a number. In this case, what's your total Morin delay?
So our total Morin delay is 5.5 months.
5.5 months. Okay, thank you, Counsel.
Thank you. Continuing with the reasons, the first reason is the actions of the accused. On the morning of March 2, 2016, when all other participants of the justice system were ready to proceed with the scheduled trial, the appellant did not appear. Inevitably, the voir dire did not conclude, and a continuation date of July 28, 2016 had to be set, which was the earliest available date in the overburdened jurisdiction of Fort McMurray. It is more likely than not that if the appellant had appeared on time, the case would have been heard on March 2, 2016.
Sorry, counsel. Just as you say that, do you acknowledge that the defendant in this case was a 15-year-old child under the YCJ? And how do you balance the responsibility of a 15-year-old child to getting to court on time, where he was only late for one of 13 appearances, versus the responsibility of the Crown Attorney managing this case, who at the last minute decided that they required an additional witness that required the voir dire in the first place.
Chief Justice, I do acknowledge that the respondent does acknowledge that there is some sort of prejudice to the 15-year-old in this case, but it is rightfully the defense counsel's responsibility to make sure that the youth in this case appears to court on time. The 2.5 delay caused here resulted in a 5-month delay that we are not attributing completely as defense delay. However, we wish that at least half of this is attributed to the young person. Even though the young person was late that day, the trial began at 2:10 p.m. 8 witnesses were heard. Had the appellant appeared on time, or that the defense counsel would have accounted for the timely appearance of the appellant, and the trial would have proceeded at 10 a.m. as previously foreseen, most, if not all, of the evidence could have been heard that day. Ultimately, it was the appellant's late appearance that created a need for the Crown to find a 5-hour trial rather than a 2.5-hour trial. Therefore, it is reasonable and fair to attribute 2 to 3 months of the delay to the defense.
Counsel, is there evidence before any court that would suggest the date that was first made available, which I have as July 28th? Is there any evidence that there would have been an earlier 2.5-hour time slot before July 28th?
Justice, I would respectfully like to direct your attention to the fact that this case demands a discrete exceptional circumstance under the transitional exception as set forth by Jordan. The jurisdiction of Fort McMurray faces endemic systemic delay, and that it would have been nearly impossible to find a 5-hour trial slot earlier than that of July 28th.
Well, exactly. But why do you say there's a 2.5-hour slot before July 28th? Because if there's not, then this is all Crown delay or institutional delay. Like, there's no evidence. There's nothing in the case that will support that. So how does this court deal with that? I mean, somebody didn't protect the record at the trial stage, and that's not appellate counsel's fault, but that's something this court needs to grapple with. But we don't know if there was dates available between March and July for 2.5 hours. Why am I going to give the Crown the benefit of that doubt?
Justice, just as the Crown gave the benefit of the doubt to the youth in this case, that it completely eradicated the first step and assumed that the youth had taken sustained and meaningful steps to expedite the proceedings. In the similar way, that benefit of the doubt may or may not be provided in this case to the Crown. However, we have to take into account that the fact that even though the trial began later than it was originally scheduled for, 8 witnesses were heard. That means the Crown was trying to expedite the proceedings as far as it reasonably could have.
The other thing I'm interested in, counsel, and then I'll stop asking questions, and this might apply more to the transcript issue, and you can address this in due course if that's the case. The trial judge made some decisions. Should we not defer to the good sense of the trial judge who's on the ground, who knows the facts? Is this not a case for deference?
We do owe deference to the trial judge. We do understand that. However, this is the same trial judge who applied the test incorrectly when considering the discrete exceptional circumstance that should have been accounted for in this event. The trial judge recourse to adopting the test of a clear and rare case, which is not the case in K.J.M's circumstance. So in that sense, the trial judge essentially erred in applying the correct test, which should have been the discrete exceptional circumstance. To expand further on that point of the discrete exceptional circumstance, the adjournment from the September 16, 2015 trial date to March 2, 2016 amounted for a total of 5.5 months of delay, which is attributed to Crown delay. We rightfully own that position. At this point, though, we must analyze what the accountability of this discrete exceptional circumstance is. Jordan defines the discrete exceptional circumstance as the events that are either reasonably unforeseen or unavoidable by the Crown and the justice system and cannot be remedied by either one of them. Here, the exceptional circumstance.
Counsel, we're talking about transcripts that are created by the court system. They're not created by the defense. When we think of a discrete exceptional event, I'm considering something that actually happened, such as where pipes would burst in a courtroom. That's unforeseen by everybody. And adjourning that case on that basis is completely unforeseen. But this is a system that creates its own transcript. So surely the production of those transcripts falls within the system itself and it is not falling on the defense.
You have 2.5 minutes, counsel.
Justice, I agree with your point. However, it is worth noting that judges are not chained to their desks. The fact that the judge was on a vacation should be accounted for in this circumstance. Had the judge been in office, she would have been able to remedy the situation by maybe listening to the audio of the proceedings rather than call for the transcript, which was incorrectly delivered to her, which was incomplete in its existence, and that is why she had to call for an additional transcript. Which
Sorry, Counselor. I agree with you that I don't believe that members of the judiciary are chained to their desk. Most certainly I'm not. But I do think that if this is not attributable to either the Crown or defense, then it needs to be attributed to the justice system in terms of whether or not a transcript error was unforeseeable or reasonably, was it unavoidable? And the reality is that the justice system could have left instructions with another individual, like I said previously, like a clerk, like an administrative assistant. It could have been rushed. It could have been a rushed transcript. Should there not be a higher standard of care delivered, especially for YCJA defendants, where every member of the judicial system should be held to a higher standard of care in terms of how these matters are dealt with?
50 seconds, counsel.
I see that my time is almost running out. May I answer your question and briefly conclude, please?
Yes, you can. Are you requesting an additional minute?
Yes.
Yes, that's fine then.
Thank you. Chief Justice, to answer your question, we do realize that the Crown should have owed a higher standard of care in this case. However, when we speak about the Jordan framework and look at the reasonings behind it, what is pivotal to note is that the Crown's ability specifically is being assessed here, not the ability of the state. In the jurisdiction of Alberta, the transcript management falls under the purview of the government and not that of the Crown. However quickly the Crown may have tried to expedite the proceeding, it wouldn't have been able to have the transcript in time, regardless of whether or not they were in office that day or not. Therefore, the respondent submits that this case did not take markedly longer than it reasonably should have, as the total delay fell below the 18-month ceiling. The total delay in this case being 16 months. The Jordan framework adequately accommodates the enhanced need for timeliness in youth cases, given that it includes the entire justice system and not just youth cases. There was no Crown delay after Jordan was issued. Seriousness of the offense and prejudice had pivotal role for 80% of this case's history, and the accused failed to satisfy the test for granting a stay below the ceiling, making the delay in this transitional exception circumstance reasonable. The respondent requests that the Supreme Court uphold the lower court's decision and dismiss the appeal. Thank you.
Thank you, Councillor.
Okay, so if everybody is gone now, at this time, I would ask all the competitors to please leave the room for judge deliberations. And you'll get notified when we're going to do a call to announce the winner of the round.